Hello, this is attorney Brian Pendergraph with the Pendergraph Firm LLC, and I am back with an update. So my last video that I did on the eviction, Governor Hogan's order on the eviction prohibition for the for tenants suffering a substantial loss of income due to COVID-19. That video is now out of date. I think in the last video, I said that old order, it only applied to residential tenants, and it affected a and only for further parent actions. It did not protect commercial tenants, and it did not protect tenants from a tenant holding over actions. Well, that's changed now. This new order has been updated to specifically to cover those. In addition, there is also new parties that are being protected in this new order. So, for example, there are residential foreclosures cannot be initiated right now, and also a lot more lending is going to go on. So, there's generally, I guess, lending limits that banks can lend money to people, but now it gets in order to deal with, I guess, COVID-19, in order to give people financial relief. Essentially, those limits are kind of being done away with. So it's a lot. I guess there's a lot more money floating around. It looks like. So again, last video is out of date, and we are here with this new one. So I'm trying to keep you guys, up to date. So let's go through this new order. That is what I have in front of you. So this is called the amending and restating the order dated March 16th, 2020. So that's what that saying is doing. Again, this is amending the last order, is going to add some clarification to it. Temporarily prohibiting eviction of tenants suffering substantial loss of income due to COVID-19. Again, that's the old title. And additionally, here's the new stuff: prohibiting certain repossessions. Okay. So I guess it's being more clear that we're going to stop evictions of people probably living in homes, but we'll see what the order has to say. Stopping initiation of residential mortgage foreclosures. Again, that's what I said earlier. Prohibiting commercial evictions and allowing suspension of certain lending limits. All right, so I'm going to basically skip over these whereas clauses. So what these whereas clauses are doing essentially is saying that we are in a state of emergency due to COVID-19. Whereas we're in a state of emergency due to COVID-19. So whereas to protect the life, property, and control public catastrophe in order to protect all these people, to avoid serious consequences. We're dealing with disaster right now, so we want to deal with it. So here's how we are going to deal with it. That's why we are passing this order. So the whereas clause is basically the justification for these new orders and things that are going on. So all right, so let's keep going. Let's go. Let's run through this order. See if I can do it pretty quickly. Let's see. Order of Governors, blah blah blah, is a order of Governor of the State of Maryland dated March 16, 2020, and the title, Temporarily Prohibiting Evictions of Tenants Suffering Substantial Loss of Income Due to COVID-19, is amended and restated in its entirety as set forth herein. All right, definitions. All right, so it's going to give us some more definitions. Chattel home. All right, so what does chattel home mean? That means a person's residence, including without limitation to mobile homes, trailers, and liveaboard boats. So what this is saying, that this order, we're making it clear that people, if you live in a mobile home, you live in a liveaboard boat. I didn't even know that was a thing, that, you can't be, you're not going to be evicted out of that. All right, so we're going to scroll further down. All right, so they're giving more definitions here. All right, substantial loss of income. All right, so they have further clarified what substantial loss of income means. I thought that the last order was clear, but hey, they wanted it to be even more clear. So what is a substantial loss of income? That means, one, with respect to an individual, a substantial loss of income resulting from COVID-19 or the related proclamation of a state of emergency and catastrophic health emergency, including without limitation to, due to job loss, reduction in compensated hours of work, closure of place of employment, or needs of Mr. Care, work, homebound age child, respecting an entity and substantial loss of income resulting from COVID-19 or related proclamation of the state of emergency. All right, so let me see if I can restate that, because again, I'm here to give you guys a sort of a simple, easy to understand breakdown from a lawyer. So what this means, if you are suffering substantial loss of income due to COVID-19, that is when you are going to be protected, essentially. But I guess they're going to explain the protection further down. But it looks like up here, they just wanted to give, in this first section, they're just giving new definitions for more clarification on what a substantial loss of income is, or even what real property is. They got a new definition for real property in there too. All right, so prohibition on certain repossessions. This is important here. Point number 3. To the extent any statute, rule, regulation of the state of Maryland or political subdivision will permit a creditor to repossess an automobile, truck, or chattel home by self-help, including without limitation to Such statute, rule, or regulation is hereby suspended until the emergency is terminated and the catastrophic health emergency is rescinded. Okay, so this is a bit broader than what I thought, actually. So it's not just, it's some let's see. So you can't just go repossess a chattel home, again, one of those liveaboard boats or mobile home, an automobile, or a truck. So people's vehicles are being protected as well. I didn't know that. So there we go. That's what this new order does. The old order didn't do that. This new order does that. Um, all right, point number 4, no initiation of residential foreclosures. So again, that's what I was saying earlier. The commissioner is, let's read the language. The commissioner is hereby ordered to suspend the operation of the commissioner's notice of intent to foreclose electronic system and can discontinue acceptance of notice of intent to foreclose until the state of emergency is terminated and the catastrophic health emergency is rescinded. All right, so in order to initiate a foreclosure, essentially, you have to notify the commissioner. And they just suspended the operation of that mechanism or of that branch of the commissioner's office. So there's going to be no residential foreclosures until this state of emergency is rescinded. Essentially, this is, again, no initiation of residential foreclosure. So if one's already been initiated prior to this prior to the state of emergency, I guess it can still go on. But we'll see if it has anything to say about we'll see if this order has anything to say about uh, foreclosures that were initiated prior to the state of emergency. With that, anyway. So prohibition on residential and commercial evictions. Point number 5. So until the state of emergency is terminated and the catastrophic health emergency is rescinded, the effect of real property 8-401. That's for 8-401. That's failure to pay rent. So the failure to pay rent remedy is suspended as follows. So that means a landlord's remedies are going to be limited. I kind of feel like I'm repeating myself from the last video a bit, so I'm going to see if I can try to summarize this, because again, I want to be helpful. I want to be quick. I don't want people watching me all day. I kind of want people to just get a good legal understanding of what's going on. So let's see. No court shall give a judgment for possession of repossession of warrant for restitution or possession of or repossession of residential, commercial, or industrial real property if the tenant can demonstrate to the court through documentation or other objectifiable means that the tenant suffered a substantial loss of income. So again, this hasn't the only thing that's changed from, I guess, my last video and the last order, at least as far as this part is concerned, is that it's not limited to residential tenants anymore. So if you are a commercial tenant or an industrial tenant, if you can show through objectively verifiable means that you have suffered a substantial loss of income due to COVID-19, then they cannot. Again, the court is not going to. They cannot award a judgment for possession in that case. All right. So moving on down. Now, this is actually something. This is important. This is new. This is different than the last video, because the last video did not include tenant holding over actions, but this one does. So this one says that until the state of emergency is terminated and the catastrophic health emergency is rescinded, the effect of RP section 8-402.1. For those of you who aren't lawyers, that is the what they're referring to is that is the code or the statute that governs tenant holding over actions. So now the effect of tenant holding over actions is suspended as follows. So no court shall give any judgment of possession, of repossession, of warrant of restitution, or possession of repossession of residential, commercial, or industrial property if the tenant can demonstrate to the court through some documentation or other objectifiable means that the tenant suffered a substantial loss of income, essentially due to COVID-19. Now, again, so if you are a tenant, and your landlord wants to, you're I guess perhaps having difficulty paying the rent or whatever it may be, and then the landlord wants to file a tenant holding over action in order to try to regain possession of the property. You can just, again, if you can show, I guess through documentation that you've suffered a substantial loss of income, that you can, I guess, not get evicted. But again, that's definitely weird to me, in a sense that I guess as a landlord and attorney, like a lot of times landlords are evicting tenants for particularly in holdover actions. It may have nothing to do with money. They just may not want the person to live there anymore. But nevertheless, it looks to me, even in that case, that tenants are still protected if they can show that they've substantially lost their income due to COVID-19. So, So perhaps even if landlords are not making a what's it called, rent the issue for why they want to evict someone for a holdover action, it looks to me that tenants are still protected. So the fact tenant, any person, miscat. All right. So let's see, blah blah blah. All right. So this section here, real property 8-402.18. So that is breach of lease. So what does this have to say about breach of lease? So if a person has been a cohabitating with a tenant, blah blah blah. Let's see. So what that's saying is that if you are suffering from a COVID-19 or under an investigation for COVID-19, then you are not a clear and imminent danger under RP section 8-402.1A1I2.8. That is the translation. That is a breach of lease action. And in other words, you cannot sue a tenant for a breach of lease if they are suffering from a if they are suffering from COVID-19 or under an investigation of COVID-19. You can't just evict someone and be like, hey, you're a threat to my health and safety. So, or to other tenants' health and safety. So, because you have COVID-19, so we're going to evict you. You can't do that. Those people are protected. So authority, that's moving down to point number 6, authorities to suspend certain lending limits. So what this does here is that, in fact, let's read this a bit. Upon the request of a state chartered commercial bank, the commissioner is hereby authorized to suspend any provision of Section 3-601 of the Financial Institutions Article of the Maryland Code to allow such state chartered bank to engage in a transaction or series of transactions exceeding the limits in that section. If the commissioner finds that doing so would not reasonably be expected to impair the safety or soundness of the state chartered commercial bank. So what that means is that these banks, they can start lending more money. There's usually limits to how much money a bank can lend, but apparently they can lift those limits. So a lot of financial relief is on the way. All right. So general provisions. No provisions order shall be construed as relieving any person or entity of any obligation to make payments or to comply with any obligation that such person or entity may have pursuant to a note, loan, agreement, or lease. So what that's saying here is that, in fact, I've been getting calls about this actually. Like a lot of people have been calling saying, "Hey, you know what? Due to this COVID-19, I don't think I have to pay my landlord any money or whatever it may be." Or this person called, or my tenant called me and said that he doesn't owe me any money. No, that's not true. You still have to. You still have the obligation to pay that person, even if they can't necessarily evict you. B. So this order remains effective until state of emergency is terminated. So that's saying or rescinded or superseded, amended, etc. So what that's saying is that how long this order is to remain in effect. And right now, it looks to me like it is kind of indefinite right now. There's not really an answer to that. So this is just what's in effect. I mean, I'm sure this will probably be amended by another order in the next few days, and I'll be doing another video shortly. All right, so let's see, blah, blah, blah. Effective any rule, statute, or agencies that is inconsistent with this order is hereby suspended. So it's saying that this order trumps things that anything that may contradict it. This order is to trump that. The underlying headings of the order for convenience references and shall not affect interpretation of this order. All right, simple enough. Any provision of order and application to any person or circumstances held invalid by any court of competent jurisdiction, all of the provisions or applications of the order shall remain in effect to the extent possible without the invalid provision or application to these person provisions of order are severable. So that is a standard severability clause. So what that means, if anything in here is, I don't know, unconstitutional, or then it doesn't make the entire document unconstitutional, just that one particular part. Again, that's the standard severability clause. And then at the end, we have Hogan's signature, April 3rd, 2020, signed by Lawrence J. Hogan Jr., Governor of Maryland. All right, so thanks for watching.